Modern Arbitration Life seminar that is dedicated to New York Convention anniversary, 60th anniversary of New York Convention, 1958, United Nations Convention on Recognition and Enforcement of Foreign Arbitral Awards. We call it the past, present, and future because we'll have today two sessions that will be dedicated to different issues relating to the convention. I thank all of you for coming here to our seminar today. I also want to say thank you very much to the International and Comparative Law Research Center, which hosts this event as usual in this great library. Also thank you to Russian Arbitration Center for supporting this event. And I want to say special thanks to the convention itself at its 60th anniversary, because of such a successful and really international treaty, we have very distinguished speakers from all over the world in both sessions, only because this convention unites now 159 countries, we can enjoy discussing the practice of applying this convention, starting from Japan, from Asia, and moving to Russia, to Kazakhstan, and to Europe further. So it's a really great opportunity. And indeed, this broad variety of countries that adopted the New York Convention helps us to discover the various approaches to application of this convention and find some interesting topics to discuss in practice. It's also very important not only from the standpoint of view of enforcement of foreign arbitral awards, but it's also a very important basis for the arbitration agreements, because actually we can say that this convention became the basis for the unilateral model law that further became model law for many national laws on arbitration, including both Russian laws. So today I would like to say thank you to the speakers of the first panel. Salient issues from the practice of its application by national courts. Today we have speakers from Japan, Yoshihisa Hayakawa, partner at Uryu Itoga law firm and professor at Rikkyo University. And I'm very happy to say that Yoshi has come to Moscow also on a very good occasion, not only our seminar, but his firm, which was founded in the 1970s in Japan, is opening office in Moscow, which will be, as I understand, the first Moscow office of a Japanese-based law firm. The office will be opened in November. Congratulations, and we wish you good luck with this. So it's really great. We also have Zhibek Karamanova, managing partner, Keremet Holding, Almaty, Kazakhstan. Welcome, Zhibek. Thank you. We have on the right hand of me Bautista, Counsel at King & Spalding law firm from Singapore, and also originally from Philippines, and also a little bit earlier from Hong Kong. So that's why we will enjoy here today the presentation on the application of New York Convention from Philippines, from Hong Kong, and Singapore. A little bit. Have 10 minutes. Yeah, but still it's a great opportunity. Thank you for coming. And also Egor Chilikov from Russia, partner at PetrolChilikov law firm. So it's very interesting because all the jurisdictions that we have today at our panel represented have adopted the New York Convention in different years. And I would like to start with Japan, because actually the sun is rising, yes, from the east, and Japan has joined the convention in 1961, as far as I understand. So please, Yoshi, take the floor. Thank you very much.
Thank you very much, and thank you, Andrey, for your kind introduction. And I'd like to explain about the Japanese experience and the salient issues on New York Convention. Okay. So Japan ratified the New York Convention in 1961, and our Arbitration Act which was established in 2003, was based on the ancestral model law, including the provisions of the enforcement of arbitral award. So since 1961, Japanese courts have smoothly issued an order allowing the civil execution based on arbitral award. So I have to emphasize no Japanese case which refused the enforcement of a foreign arbitral award by public policy reason or arbitrability reason. It is described in the paragraph 2 of the Article 5. And issues which were mainly examined in the Japanese case is a due process problem, which was described in the paragraph 1D of the Article 5. So salient issues in the recent cases and academic discussions in Japan as follows. So this is a brand new Supreme Court decision which was issued December 12, 2017. One of the arbitrators failed to disclose the following fact during the arbitration proceedings. He belonged to the Singapore office of a global law firm like King's and Spalding, and one lawyer joined the San Francisco office of the global law firm during the arbitration process. And the new colleague had served as a counsel for a lawsuit in the United States before the participation and continued to serve as a counsel in the lawsuit. So one of the defendants, the new colleague represented, is the subsidiary of a Japanese company. But the claimant in the arbitration is another subsidiary of the parent company. So it means a sister company, so-called. And for the one sister company, arbitrator serving as arbitrator, and another sister company, the person is serving as a counsel, but they are belonging to the same law firm. And this fact was not disclosed during the arbitration proceedings. So does the arbitration award without appropriate arbitrator's disclosure infringe paragraph 1D of Article 5? This is a question. And the arbitrator submitted a declaration at the time of the appointment. There was a possibility that his colleague might be involved in one or more cases or deals of the affiliated companies of the party. So that he tried to excuse in advance. And how the Japanese court decision, treated these issues. First tier, Osaka District Court decision, 17 March 2015. The undisclosed fact is not the one which can be used for the challenge of the arbitrator or which influenced the conclusion of the arbitral award. The claimant did not argue against the declaration and could have expected such a situation like the undisclosed fact. The infringement of the obligation of disclosure was not serious, so it did not infringe due process. This is the conclusion of the first tier. But second tier's decision is completely different. Osaka High Court, 2016. The obligation of disclosure is an important principle a party can exercise the right of challenge only based on the concrete information by the disclosure. So declaration cannot be regarded as any kind of disclosure. So an excuse of difficulty of entire conflict check in the global law firm cannot be accepted, the court said. And finally, the obligation is regarded to be infringed in either case. He failed the conflict check or he did conflict check but did not disclose. So it infringed due process. That is the conclusion of the High Court. How about Supreme Court? So the declaration cannot be regarded as any kind of disclosure. This conclusion is the same as the High Court. But second point is a little bit different. The obligation of disclosure is regarded to be infringed in the case the arbitrator knew the fact but did not disclose it, or the arbitrator failed to research to a reasonable extent. So it is not clear whether or not he knew the fact or he failed to research to a reasonable extent in this case. And of course, Supreme Court is not the forum, for the fact finding. So the case reversed and remanded. So now this case is still pending, and the High Court is now busy for the fact finding. So this is a brand new case, and we are now facing. And another one is Tokyo District Court 2011. This is only one case which refused the enforcement in Japan. A sole arbitrator made the following mistake in the arbitration proceedings. An issue clearly disputed between the parties was categorized as the undisputed one between the parties in the arbitration proceeding and in the final arbitral award. And the district court found the infringement of due process in the arbitration proceedings, and even after the appeal, Tokyo High Court issued the same decision. So this is only one case in Japan which was refused the enforcement. And another interesting thing is Tokyo High Court, for example, 2018, Tokyo District Court reviewed an arbitral award in the manner of revision of form. So it means they try to change the fact finding. But High Court criticized such a manner and reversed the decision. So the arbitral award could survive. And another case, Tokyo District Court 2017, it was claimed arbitrator's determination on the applicable law was incorrect, and it infringed the due process. But Tokyo District Court regarded the problem is only the issue of substantive law and the prohibition of the revision of form, and so the Tokyo District Court did not accept this kind of the argument. So after the appeal, Tokyo High Court and Supreme Court followed the decisions. So these are the real cases in Japan, recent one, and so the change the direction to the academic discussion. For example, enforcement of the set aside or invalidated award. That is, of course, the very interesting topic still in Japan. And since the famous Kuromaroi case decision in 1996, enforceability of the set aside award or invalidated award under the New York Convention has been discussed even in the academic scene of Japan. And Article 5 of New York Convention uses may be refused. It seems that New York Convention gave a member state a room to enforce award even if the award does not satisfy the requirement in Article 5. And the Arbitral Act of Japan uses the same expression, so that if the case actually comes, we have to discuss these issues very seriously. And I personally researched every minute of the drafting process of the New York Convention. I found the reason why they use this expression, but I have no time to explain that. In the later stage, in the Q&A, I will disclose this one. So apart from the history, the majority view used to criticize the Kuromaroi decision from the viewpoint of the worldwide uniformity of the arbitration. So the set-aside invalidated decision should not be enforced in any of the other jurisdictions. However, I believe that another view is now becoming a majority one. The new majority view supports Kuromaroi decision from the viewpoint of the necessity of a countermeasure against the abusive setting aside of the arbitral award in the emerging market countries. So in the same way, Japan joins the activity of, for example, ICC Arbitration and ADR Commission, which regularly issuing ICC guide to national procedures for recognition and enforcement of awards under the New York Convention, and it regularly issued, and so that we can easily find which country refused the arbitral award by the public policy or some other reasons. So finally, I would like to explain the additional issues, for example, commercial reservation of the United States and the award of investor state arbitration can be categorized as a commercial one, and it was actually debated in the one US case, and it was refused to regard as a commercial one because the relationship between the investor and the state is a public relationship, not commercial one. So this is the one possible very serious problem. And Taiwan Arbitral Award it is not a member of the New York Convention because it cannot be a member of United Nations. So can we enforce this award under New York Convention? Of course not. How can we enforce this one? Or settlement award, can we enforce settlement award under New York Convention? It is still debated. And reaction to the Singapore Convention, which is newly created for the enforcement of the mediation, the solutions. But how can treat this one, and the Japanese academics are still debating. So thank you very much.
Thank you. Thank you, Yoshi, for this very interesting overview of the past history of applying of New York Convention in Japan, and also pointing out some questions for the future, I think, too. So first of all, I would like to ask my co-panelist. Colleagues? Okay, well, I have a question then, if possible. So you said that it was very interesting on one of your first slides. You said that there are no examples of not enforcing the arbitral award in Japan on the basis of arbitrability and public policy. So in your opinion or in your experience, what's the reason for it? Either the parties don't raise these arguments, the Japanese parties who oppose the enforcement usually, I think, or the courts do not apply it regularly, or just they have very liberal, broad approach to these pro-arbitration approaches to these categories.
Thank you for your question. And of course, every single council for the try to refuse the enforcement, try to pick up every single reason, including public policy, every time. But Japanese court continuously try to refuse such an argument, the public policy. So perhaps it will be it should be categorized in the latter part, the liberal approach of the Japanese court to the arbitral award. That is my answer. Thank you.
Thank you very much. Okay, so if there are no questions, I suggest that we move to another presentation, and I would like to give floor to Jun Bautista, who will tell us about Philippines, another very interesting jurisdictions, and also Singapore and Hong Kong. Yeah. So I would remind that Philippines joined the New York Convention in 1967. So it's about 50 years of experience. So please tell us about the past of the convention in Philippines, in your native country.
Yes, so it's not been a pleasant experience, that 50-something years. It's not always been pleasant. And unlike Japan, the Philippines actually has used the ground of public policy to not only to refuse the enforcement of foreign arbitral awards, but it has also, in fact, set aside foreign arbitral awards. Take note, a foreign arbitral award on the basis of violation of public policy. Probably the most famous case, which has actually reached international attention, is this case called Luzon Hydro versus Bye Bye. So this was actually an ICC award which was rendered in Singapore, and that was actually a rather prominent tribunal. I think it was Neil Kaplan, Michael Pryles, and Clyde Croft. And so when they tried to actually enforce this in Philippine courts, the Court of Appeal, which is one court which is below the highest court, the Supreme Court, actually not only refused to enforce the arbitral awards in the Philippines, but in fact it set it aside. So they're setting aside using a case called Asset Privatization Trust versus Court of Appeals. Now, the use of that case is actually inappropriate for the simple reason, actually, that that Asset Privatization Trust case involved a domestic arbitral award and not a foreign arbitral award. And so in the reasoning of the Court of Appeals was actually erroneous on that front. And that's why it thought that it could set aside this ICC arbitral award rendered in Singapore. But then they also said, oh, one of the grounds for setting aside the foreign arbitral award is not only the violation of public policy, but actually manifest disregard of the law, which they borrowed from US jurisprudence. So on those two fronts, the Court of Appeals actually made a mistake. So if you can see on that slide, which is highlighted, they've actually cited US jurisprudence, first on manifest disregard of the law, and on public policy, they said, oh, the award which the ICC tribunal rendered has a section on costs, and in that section, the arbitral tribunal decided to follow the event principle, where the winning party basically gets its costs paid for by the losing party, and the Philippines follows the US rule generally, whereby each party bears their own costs. And so the Court of Appeals, when it examined that decision by the arbitral tribunal, said, well, that's against public policy because it penalizes the right of litigants to go to arbitration. And so on that basis, the Court of Appeals also said, this violates public policy, we have to set it aside. So that is the famous case of Luzon Hydro versus Bye Bye. The aggrieved parties actually appealed this decision to the Supreme Court. The parties, however, settled the case, and so we could not get a decision by the Supreme Court to see whether or not this would actually still be good law. Okay. The next case that I'm going to talk about very briefly is the Korea Technologies versus Lerner case. This is a Supreme Court case. This involved an arbitration in Korea. This, however, does not per se involve an enforcement of an award. It is relevant because there is some obiter dictum by the Supreme Court in that, similar to Luzon Hydro, the Supreme Court in this case actually said that it has the jurisdiction, or Philippine courts have the jurisdiction to set aside foreign arbitral awards. So this is the highest court of the Philippines saying that Philippine courts have jurisdiction to set aside foreign arbitral awards. This is in 2008. By, again, no less than the highest court of the Philippines. Conscious of these pronouncements, there was a committee formed by the Supreme Court in 2009, and in 2009, that committee enacted the ADR rules of court. And the ADR rules of court in 2009 provided that the enforcing court in the Philippines could only refuse enforcement of a foreign arbitral award only on the basis of New York Convention awards. So that's at least a positive. And it also said that it should not disturb or review the arbitral tribunal's findings of facts and interpretation of law. And it also said, sorry, going just back here, a Philippine court shall not set aside a foreign arbitral award. So now it's very explicit in the ADR rules of court that a Philippine court cannot do so. So that's at least a step in the right direction by the Philippines. So it's course corrected what both the Court of Appeals and the Supreme Court erroneously ruled. Also, the implementing rules of the ADR Act of 2004, which was passed in 2009 also course-corrected that public policy statement by the Court of Appeals, because the Court of Appeals in Luzon Hydro essentially said that awarding costs to the prevailing party violates public policy. Well, now, under the implementing rules of the ADR Act of 2004, it is actually recognized as not violative of public policy. In fact, it says that the general rule is to provide costs to the prevailing parties. So again, that's a course correction by legislation. And in 2012, the Supreme Court was faced with an enforcement case, and one of the parties that was trying to refuse enforcement or resist enforcement put up the novel argument that, well, the party which was trying to enforce the foreign arbitral award actually has no capacity to sue because that party was not doing business in the Philippines. There's a rule in the corporate code of the Philippines which says that only entities, foreign entities doing business in the Philippines can sue. And so it raised that argument in the corporation code as a way out. But the Supreme Court said, no, that actually doesn't work because, again, only the grounds provided for under the New York Convention are valid grounds, and that's not one of the grounds provided for in the New York Convention. So again, that seems to be a step in the right direction by the Philippine Supreme Court, as well as the administrative agencies involved in enforcement of arbitral awards. Now, there are, however, some unresolved issues in the Philippines. One of them is the construction arbitrations. Just very briefly, in the Philippines, there is an executive order which requires that all arbitrations of Philippine construction disputes be resolved through a Philippine body called the Construction Industry Arbitration Commission. Now that CIAC body is a government-affiliated body, and this was created way back in 1985 when arbitration wasn't even considered very popular, and the intentions were very noble. However, the Philippine Supreme Court has interpreted that executive order as giving that body as having original and exclusive jurisdiction to hear arbitral disputes involving Philippine construction projects. And so the question then is, what if the parties agree to, let's say, ICC arbitration, such as in this case, China Chang versus Rosal, whether or not the CIAC would have jurisdiction. And the Supreme Court in this case said, well, as long as the CIAC, even if the parties had agreed to a different arbitral forum, such as an ICC arbitration, the fact that there is an executive order which gives the CIAC exclusive jurisdiction, it's as if the law has been written into the contract of the parties, and so the CIAC would have jurisdiction to hear this dispute. So in this case, even though the parties had agreed to ICC arbitration, Rosal then filed for arbitration with CIAC, and the Supreme Court said, yes, CIAC has jurisdiction. But the reality, though, is that a lot of parties are not satisfied with the CIAC regime. A lot of parties still go through Hong Kong or Singapore or the ICC. So in this case, for instance, there was a big dispute between a Chinese state-owned enterprise and the Philippine government, and that dispute went into arbitration in Hong Kong under the Untitled arbitration rules. And actually the arbitral tribunal ruled that it had jurisdiction, notwithstanding the Philippines' defense of SEAC having exclusive and original jurisdiction. But before the tribunal could rule on liability and quantum, the parties actually settled that one. So it would have been interesting to find out if the Chinese state-owned enterprise, if it had won on quantum liability and quantum, whether or not it would have been able to enforce that award in the Philippines. Similarly, there was a similar case, Bachmann versus Weir. Now, this is interesting because Bachmann, which is the Philippine company, was the one that filed for ICC arbitration following the contract with Weir. Weir opposed the jurisdiction of the ICC arbitration tribunal and actually filed for CIAC arbitration. And so it was actually a race between the two arbitral tribunals. The ICC arbitral tribunal was the one that was able to issue the decision first. And actually the tribunal told Weir that it has jurisdiction and that it should desist from proceeding with the CIAC tribunal. And so on that basis, Weir withdrew the CIAC arbitration. And at the end of the day, the parties had actually settled that arbitration. So again, it would have been interesting to find out if a Philippine court would enforce such an arbitral award, because, again, the Supreme Court has said in the case of China Chang versus Rosal that the CIAC has original and exclusive jurisdiction over construction disputes involving Philippine projects. Now, comparing the Philippines to other jurisdictions, particularly Singapore and Hong Kong, the Philippines is, as I said, it hasn't had a illustrious history of enforcing the New York Convention, unlike Singapore, which recently was, there was a survey conducted by Herbert Smith very recently in celebration of the 60th anniversary of the New York Convention, and that survey basically said that 91% of the respondents voted Singapore as the top place in the ASEAN region for enforcing of arbitral awards, followed closely by, well, not even close, I think Malaysia was a distant second at around 69%. Philippines and Thailand were voted as improving, but still had a long ways to go. Hong Kong, on the other hand, has also had a pretty good history of enforcing arbitral awards, not just foreign arbitral awards, but mainland awards. So if you look at this graph, you could actually see the number of times that Hong Kong has enforced arbitral awards. If you see that blue graph, that blue line, you'll see that on average, Hong Kong gets around 20 to 30 applications to enforce arbitral awards, and the red line is basically the number of times the other side would oppose enforcement, and the green line shows the number of times the court has refused to grant the order to enforce. So it's actually very, very slim. So it's on average you get 0 chances of having your award of the enforcement to be denied. So that's basically the story in the Philippines, Singapore, and Hong Kong.
Thank you, Jun. Dear co-panelists, do you have questions? Okay, audience, do you have any questions? Okay, Yoshi, yeah, please.
Thank you very much. I have a question. So you explained about the Philippines experience, and so at least they're moving to the very right direction, but still there are the cases which try to refuse the enforcement of the arbitral award for the reason of for example, the public policy, something like that. And my question is why?
Why?
Because I know that, for example, in some emerging markets, for example, local judges have deeply connected to the local community. In that case, that they try to protect the local community or local company, and so they try to use the public policy for the refusing enforcement. And I believe in China sometimes happened in the local areas, but at the same time, Supreme Court does not have any relation with such a local community, and the Supreme Court China relatively, care about the reputation of the state of China. So now the Chinese Supreme Court try to, change such kind of the trend, and they try to review very severely, to such a local decision which try to refuse the arbitral award in the local community. So that could be a reason, or sometimes, the judge did not have enough knowledge of the arbitration system. I introduced one Japanese case which influenced the revision of form prohibition, and but that is clearly the lack of the knowledge for that judge. So so it was criticized by the appellate body, and so that could be a reason.
Yeah.
And how do you estimate, or how do you analyze, why they try to use a public policy argument or refuse?
I think it's, based on my experience, and I've had to enforce a foreign arbitral award in the Philippines, I think it's the latter. I think a lot of courts in the Philippines just do not have the experience to enforce a foreign arbitral award. And the training of court judges, especially appellate court judges, is to basically look at lower court judgments and see, okay, what have they done wrong? So that's always the mentality that an appellate court judge would have. And so I suspect that that's where they're coming from. It's just, for instance, when I went to law school, I didn't really know anything about arbitration. It's only when I started working at a law firm, that's when I started getting exposed to arbitration. So I think I don't think there's anything sinister about it. I think it's just, that's really the reality. They just don't know enough about arbitration.
I have some questions too. First of all, I would like to ask whether Philippines is closer to the civil law jurisdiction or the common law, because I understand that the history is that it's more civil law jurisdiction, but there was some influence of common law, I think so, at the same time.
I think we're kind of schizophrenic. We're both.
Yeah.
So we have about 400 years of Spanish history. So we got that from we inherited the Spanish Civil Code, but the Americans had about 50 years of colonization, and so we got the common law from the U.S. So it's kind of a mix between the two. So yes.
It's interesting. I ask because on your slides I noticed that at first you referred to the ADR rules of 2019 and then to like Adr Act of 2004. So what's the legal force of these documents? It's something like the ADR rules, it's something like a guidelines for the courts. Is it kind of soft law or it's obligatory for application? So what's the nature of this?
Okay, so the Adr Act of 2004, that was created by like Parliament or Congress. The ADR rules of court, those are the rules of court which Philippine courts must follow. The rules of court were created by, as I said, the committee composed by the Supreme Court, but ultimately the Supreme Court, which is the highest judicial body of the land, they're the ones who sign off it. So they have supervision over all courts of the Philippines, including themselves. So it is obligatory.
Oh, okay, thank you. And I have one last practical question. So if I need to enforce the award in the Philippines and I am drafting the arbitration agreement, what is your recommendation? To which institutions or to which seat of arbitration the Philippines court will be more friendly? So if I choose either European, like ICC, LCIA, SCC, or it's better to choose HKIC or SIC as closer seats, closer venues for arbitration?
I'm not really sure that my guess is anyway, because I had an ICC award that was seated in Hong Kong, and it still took more than a year for the enforcing court to be able to do anything with it, although it probably helped that the other side was a very creative Philippine law firm, which I'm actually now co-counsel with in 2 of my cases. But they were very creative, and they were making the case very complicated. We were trying to make it simple, and so I don't think it had anything to do with the fact that it's an ICC award from Hong Kong or Singapore or from Europe. It's just, I think, courts just need to be more familiar with arbitration. It was, I think, the first time that court, and this was not in Manila, we were trying to enforce outside of Manila, and when they saw all these files, like all these, because we had to basically recreate all of the filings in the arbitration, and they basically saw like 30 boxes of files. Apparently the clerks were like, what the hell is that? So yeah, so they themselves were like, okay, we don't know what we're doing. So you could already tell that they were a bit intimidated by the whole process.
But finally you succeeded.
We settled.
Settled.
Because what was happening was they were also trying to set that aside in Hong Kong. So we were trying to enforce immediately in the Philippines. They were trying to block it on the basis of a set aside application is on foot in Hong Kong. And we said, well, you're not bound by that. Okay. Of course, the judge, I think, was also just confused.
Okay, thank you. Actually, then I have a question to Yoshi in regard of Japan, because Jun mentioned that the dispute was settled, the enforcement was settled. So we hear a lot that in Japan it's really common to settle the disputes. So parties prefer to settle the disputes. Is it the same with the enforcement proceedings, that the parties prefer at some point of time to settle and not to go forward with the enforcement proceedings? Certainly there are cases, as you said, that go to the Supreme Court and through all the instances, or just maybe there are more cases which are being settled.
Yeah, I'm not sure I could catch your question correctly, but at least Japan is very famous as a settlement culture, and fortunately, unfortunately, the Japanese business corporation try to propose a settlement to the counterparty, even if the counterparty's culture is so different. So sometimes, the Japanese business corporation, unfortunately, they easily accept very unfair the settlement proposal, and because of their own culture itself. And but after the arbitration proceeding, they got the arbitral award, which is favorable to them, and in Japan, at least, it is very easy to enforce the arbitral award. So at this stage, there is no incentive to, go to such kind of settlement. So usually the enforcement process is smoothly conducted, and they got money. So
it is too quick to have any space for settlement, like in the Philippines, where it takes 1 year to enforce. So, and you have enough time to discuss the settlement and not to proceed with the enforcement.
Yeah, for example, I showed the timeline, and so the District Court 2002, the 15 and the 2016, the High Court 2017, the Supreme Court, and so if they try to use the 3 steps, but you only just wait for the less than 3 years. So I think the enforcement process itself is very smooth, and that they do not have to be involved again in such kind of settlement process.
Okay, thank you very much. Now we move to Kazakhstan, the youngest jurisdiction to join the New York Convention due to historical reasons. It was 1996. So I now give floor to Zhibek. Please share your experience about the past of application of New York Convention. Yeah, clicker. Yeah. Thank you.
Dear colleagues, guests of our today's conference, I'm very honored to be the arbitrator of Russian Arbitration Center, and of course pleased to be invited as a speaker to today's event. Due to time constraints, I will very briefly discuss the arbitration issues in Kazakhstan, and there are some. Kazakhstan is a relatively young country, but with a history of almost 8 centuries. We actually did have arbitration in various forms, but I would like to stop on the history of arbitration development right after Kazakhstan gained its independence in 1991. So the first stage was when on 5th of October 1993 there was Arbitration Commission and the Chamber of Commerce of Kazakhstan created. And at the same time there was first arbitration court organized as well. But this arbitration court was governed by the rules on arbitration court approved by the Cabinet of Ministers of Kazakhstan in 1993. Therefore, it was kind of quasi-state arbitration court. Since not everyone really understood what arbitration was at that time, there were a lot of clashes with general prosecution body, which tried to challenge the decision of this single arbitration court. Kazakhstan joined New York Convention in the end of 1995, on 20th of November 1995. However, during these 5 years, it really met a lot of challenges. For example, there was an issue of accepting this international agreement due to its ratification issue. So, for example, Article 501 of Civil Procedural Code, it states that foreign judicial acts and arbitral awards are recognized and enforced in Kazakhstan if such recognition and enforcement is provided for by legislation, international treaties ratified by Republic of Kazakhstan, and there was a recent amendment, all on the basis of reciprocity. And many of the lawyers at that time thought that the decree of the president was not equal to ratification, because ratification is the condition for international treaty to have the priority over national laws. And therefore, there should have been a separate law on ratification. However, the practice showed that New York Convention is still good for direct implementation, because the decree of the president is the part of legislation according to the law on legal acts of Kazakhstan and according to the Kazakh constitution. Therefore, New York Convention constitutes the part of the national legislation and allows recognition and enforcement of foreign arbitral awards in accordance with this Article 501 of Civil Procedural Code. The second stage was quite chaotic because the state arbitration courts, they were liquidated. There was a law on order of economical dispute, Resolution 1993, which had the clause on obligatory enforcement of arbitral awards. But then there was a new Civil Procedural Code adopted, which did not have the provision that foreign arbitral awards shall be directly enforced. But in the end of this, let's say, there was about almost a decade from 1998 to 2004. In the end of this period, there were 2 finally laws adopted, which were the law on domestic arbitration and law on international arbitration. They were amended many times during 12 years during which they were in force. The main distinction was that domestic arbitration courts, they should have been reviewing the disputes between residents of Kazakhstan, and if there is a foreign element, there shall be international arbitration law applied. So finally, on 8th of April 2016, there is a new arbitration law passed, which basically united previously 2 documents, consolidated provisions of two laws. So the procedures became the same as for domestic disputes and international arbitration. So there was no difference for residents and non-residents. The main thing is that finally there was a little bit more clarity on what is public order. Before, the public order had the definition that it is basics of state and public organizational structure, and now it's basics of the legal order. And the same definition is determined in the Civil Procedural Code of Kazakhstan. Also, there was one more novelty, that there is no more ground for challenging the arbitral award as contradiction to the principle of legality. There were a lot of cases when there were a lot of disputes between the lawyers and state courts, when state courts actually did challenge the arbitral awards on this on the basis of this principle. One of the minuses of the new law on arbitration 2016 that there was a new requirement for arbitration agreement. So the law basically specified what shall be contained in arbitration clause. So for example, they added intention of the parties on transferring the dispute of arbitration, even though, of course, there is a still old definition that there should be indication of specific arbitration. But many lawyers are now asking each other, what does it mean? Does it mean that arbitration clause shall now be with the wording that parties intend to transfer the dispute to arbitration, or how it shall be formed? And the main thing is that if there are state organizations, state bodies, or state companies, or quasi-state companies, meaning if that company belongs to the state with 50 and more %, it shall receive the consent of the competent state body or the local executive body. Otherwise, this arbitration agreement will not be valid. Of course, this applies to exit arbitration especially, and Kazakhstan, unfortunately, or fortunately for some lawyers, it was the party of several big cases in Washington, D.C. And now I guess the state is trying to protect itself, and no one knows whether, if, for example, such quasi-state company receives such consent, whether it can be withdrawn on a later stage or not. There was a big issue, and finally resolved, that before we had, basically just 1 year ago, we had this clause that parties, before the dispute arises, they have the right to unilaterally refuse from transferring the dispute to arbitration. So this clause existed for almost 1 year after the new law on arbitration passed. And of course, many lawyers, they thought that it's not acceptable. It contradicts to many international agreements. And finally, it was cancelled, this provision, only in 2017, so 1 year ago. This was just the novelties in the law that we have now, even though that arbitration courts in Kazakhstan, for example, they are of course independent. We have now a new body which is called Arbitration Chamber, and all courts shall register with this chamber, and all arbitrators shall be listed there with this chamber. And moreover, there are certain authorities of the chamber. For example, they can approve the rules on the process of keeping the cases by established arbitrations. In my opinion, it kind of touches upon the issue of confidentiality of arbitration. And the second thing is that it can make a decision even on termination of authorities of a specific arbitrator appointed for specific case. So of course it more relates to Kazakh arbitration courts, but still, in my opinion, not good. So these are the grounds of some new grounds, additional grounds for cancellation of arbitral award, which in my opinion do not fully correspond to New York Convention provisions. For example, if there is already issued a court or arbitration court resolution on the same party's dispute on the same grounds, then it can be cancelled. And if arbitral award does not correspond to the requirements, for example, it is not in written form, but of course usually it's in written form and not signed by arbitrators, it can also be cancelled. The same thing about, there is a separate Article 57 of the new law on arbitration that court can refuse in recognition of and enforcement of arbitral award if there is already a court resolution or arbitral award on the same matter issued, and if the issue of arbitral award was possible as a result of criminal violation, or basically crime, determined under the court judgment which came already into force. This is quite new. We do not have any cases on this ground yet, but this is just for information that in Kazakhstan there are some additional grounds for non-recognizing the arbitral award. And I would like also just to briefly mention recent case. It does not relate to international foreign arbitral award. It relates to the arbitral award of Kazakh arbitration court, but still it might be interesting for you. That court in Uralsk city, so it's West Kazakhstan, 1 year ago, on 1st of November 2017, cancelled the decision of arbitration court, saying that the amount claimed was 2 times higher. So the penalty which claimant should have been receiving was 2 times higher than the principal amount of the loan. Why? Because we have the novelty in our civil code that that court can decrease the amount of penalty if the party requests so. So in my opinion, it's something which is outrageous and basically the court reviewed this dispute on merits, which is not acceptable. So it's, I think, interesting also to know. Even though our panel is not about the future, just wanted to let you know that a lot of new institutions in Kazakhstan are being organized. For example, Astana International Financial Center, which is following Dubai example as Dubai International Financial Center. We have new arbitration court, arbitration center, court. So I would like to invite all of you to Kazakhstan. Please visit. I hope that all of your arbitral awards will be recognized and enforced in Kazakhstan. Thank you.
Thank you, Zhibek. Do you have any questions, colleagues? Please. Yeah, we have a question.
Could you tell me what is the legal form of your arbitration chamber? Is it a non-commercial organization or is it a state one?
Yes, it is non-profit organization. It's basically in the form of association, but it is being governed by the law. So.
Okay, one more question. Yeah, please, interesting.
Thank you very much for such an informative presentation. I got 2 questions, if you allow me. Yeah, the first one is my special area of interest, concerns interim measures. Whether do you have any experience, speaking from your own personal experience dealing with this kind of issues, whether the arbitration court are reluctant to provide the interim measures, or you have any data, or you have just, I would like to know some information from you. And the second one, as Kazakhstan as a CIS country, or having more or less same legal framework as Russian one, I was wondering, in view of the fact that you mentioned in 2016 there was a reform, whether we can make some parallel saying that there are a special type of cases. Here I'm wondering about the corporate, disputes, for example, speaking about the Russian ones, if there are some type of cases which are considered as arbitrable, not arbitrable, or conditionally arbitrable. So I was wondering if there is such a differentiation, or if you can make some parallel with Russian legislation, which and the reform as well. Thank you.
Thank you for your questions. Well, about interim measures, in my experience, there were no any issue of state court providing interim measures. Freezing the bank accounts, putting the incumbency to the assets. So there was no any issue. State courts are willing to do this if you provide the application, the proof that you apply to the arbitration court. And about the second question, unfortunately, I'm not practicing law in Russia. I cannot do the comparison. However, about Kazakh legislation, so basically it's all disputes arising out of civil legal relationships. So there shall be no, for example, employment, labor disputes there, family dispute there, and there is a separate article which states about the arbitrability of the disputes. For example, as I already mentioned, if there is no consent of state for quasi-state companies participated in the arbitration hearings, then of course it's not also arbitrable. But if you want to know more about this, I can provide you with detailed answer later.
One more question? Yeah.
Thank you for sharing the knowledge with us on evolving legislation in Kazakhstan on arbitration. I'm particularly curious about this requirement for state-controlled companies to obtain special governmental approval for entering into arbitration clause. If you know, what is the kind of a prevailing view among the lawyers in Kazakhstan, whether this requirement goes beyond just the direct state-controlled companies, but whether it applies to their subsidiaries? Because as a hypothetical, is like Samruk Kazani being a large state-controlled fund that certainly has subsidiaries even outside of Kazakhstan, and they enter into lots of joint venture and investment deals all over the world. And I'm curious whether for each of their transactions would they go for the, I don't know, Ministry of Justice of Kazakhstan to get an approval.
Yes, you're absolutely right. It does apply to the subsidiaries of quasi-state companies. So yes, Samruk Kazana is one of the good examples, which does have a lot of companies all over the world. But each of this case shall be reviewed separately, and as I mentioned, it applies only to the companies which have more than 50% stakeholding by state. So, but in general, yes, it does apply to all of these companies below Samruk Kazana only.
Thank you. We have one more question.
Yes.
Yeah. No, yeah, it's okay. Yeah.
Thank you. I think the question about the interim measures is interesting for all speakers and all jurisdictions for the following reason. Many decisions on interim measures are made with orders because they should be varied, and the natural form should be an order. But as you know, sometimes it's by way of an award. And there are also some institutions which would suggest that certain interim measures, certain categories of interim measures should be made with the form of an award in order to facilitate recognition and enforcement. And maybe along those lines, we could ask the panelists whether you have been confronted with the situation of a decision which would be in nature on interim measures, but which would be described as an award, and whether then you have issues as to the recognition and enforcement of that decision in your countries.
Please, colleagues, can you please comment?
So first of all, the New York Convention requires the final and conclusive award. So the interim measure in nature, interim one. So it is a contradiction, if we try to enforce the interim measure under New York Convention. At the same time, we have arbitration law, but arbitration law have the similar requirement of the New York Convention, and so we at present we do not have any process to enforce the interim measure in the Japanese court. However, the Arbitral, the 2006 new version have some kind of the enforcement process of the interim measure, and we have not yet adapted this one, and so that is partly the reason why the interim measure could not enforce in our Japanese territory. But we are now in the process of revising our new arbitration law, and there is still debate about whether or not we should adapt this one. And if we adapt, we could do it in the Japanese court, but not yet. That is my answer. Thank you very much.
Thank you. Colleagues?
And additionally, I don't think that if the name is award or name is order, it's a very formal issue, and I don't care. The substance issue is very important. So the substance is in term, at least under the present New York Convention, we cannot do it.
Thank you. Any other comments, colleagues, on this? Egor?
Well, I can speak for Russia. Russian courts do not enforce the interim measures, disregarding how the ruling is actually worded, whether it's worded or named as an award or named as a ruling or named as something else. But the usual tactic is to the courts may render interim measures on their own in aid of arbitration, and the usual tactic is to get something from the arbitrator and then to apply for similar ones but rendered by the court in aid of the arbitration. Like having something by the arbitrator beforehand usually helps. Of course you can do without that, but it usually helps. So that's the approach.
Yeah, please.
So one of the bright sides of Philippine enforcement of foreign arbitral awards is actually they do allow the enforcement of interim measures in foreign seated arbitration. So that's actually very clear. What is unclear is the enforcement of an award by an emergency arbitrator. So that was actually a live issue that's currently I'm trying to think whether now that's an issue, because that was actually one of my cases. There were parallel proceedings, and we also had it overturned when the tribunal was constituted, but at the same time, the other side was now trying to do different things with it. So one of our defenses was it's not, the legislation doesn't cover emergency arbitrator awards. But there is also legislation that is being proposed that to allow, or at least to clarify, that emergency arbitrator awards are covered. Singapore and Hong Kong have now taken that position.
Thank you, Jun. Well, I suggest to move forward. We started a little bit later, so we have 15 minutes more, and now we move to finally Russia. I think all formally Russia joined New York Convention much earlier, but I think that Egor will be speaking about the last 20 years of application of the convention. Please, Egor.
I'd like to speak of a broader history, but unfortunately I'm not aware of any single instance of application of the New York Convention prior to 1990s. Maybe that's just a gap in my education, but I'm not aware of those. So yeah, we USSR and we as successors to the USSR have formally joined the convention in 1960, but indeed I will be speaking just about 20 to 25 years at best of experience with the convention, just because of the historic events of which you are well aware of. An interesting feature is that the convention was quite quickly after it came into practical application superseded by the national legislation. First it was the model law UNCITRAL model law adopted in 1993, then the procedural codes, then it was the arbitral reform which updated these regulations. An interesting consequence of that is that, at least I have a feeling that it's difficult to speak about practice of use of the convention in Russia, because Russian courts are using national legislation which adopts and embodies the ideas of the convention, but not the convention itself. I think most of you will hardly go to a Russian judge and try to argue based on the convention itself, like bringing travaux préparatoire to the convention, explaining how it was adopted and what were the initial ideas of the drafters behind the convention. You will normally proceed with the arguing based on the national legislation. And we were lucky enough that the national legislation which we adopted was in 1993 already more enhanced and more elaborative than the convention itself, because the UNCITRAL model law was a more advanced document than the convention. So we, to a certain extent, benefited from that. Of course, a negative downside of that is that the practice had a bit detached from the international background of the convention, because the courts are applying these ideas as their national legislation, but not as something which comes from international obligations of the Russian state coming from the New York Convention. I have compiled some statistics for you. We are less fortunate to have just one or two cases where enforcement was refused. Like you all know that we have many. This actually implies that I will not be talking later in my presentation about individual judgments. I can only talk about trends, because to talk about individual judgments will take too much of your time today. And picking up on the Singapore example, I think like where John mentioned that 91% of users in Singapore are satisfied with how courts are dealing with the New York Convention. I think we will have, I'm not aware of the statistics in this respect, but I think we will have an opposite result, most likely. I would say hardly 10% will say that they are satisfied with everything what is happening. But going back to the statistics, Professor Korabelnikov has reported for the first decade of 21st century that we have a rate of less than 50% enforcements of international arbitral awards, meaning that less than 50% of applications have been granted for enforcement. The more recent study conducted by the Russian Arbitration Association showed that in the past 10 years the percentage has actually grew up quite nicely till 80 and 90%, sometimes reaching almost the top levels, and which effectively places us, if we compare with the statistics of Professor Vandenberg, among the normal trends in the states which are parties to the convention. Of course, that statistics is not that well representative, because, say, if you take the top 10% of the biggest cases, the cases which involve the biggest sums, then the percentage there will be a bit different, because the greater is the sum in dispute, the more problems you will normally encounter with enforcement of this sort of award. And a subjective feeling is that for these sorts of cases we're still in the range of 50%, if not less, of enforcements. So we see improvements. We are generally doing better, but there are some issues, some points for concerns. And in the next two blocks of this presentation, I will talk about actually two things. I will concentrate about some specific topics related to enforcement of arbitral agreements, and topics related to enforcement of arbitral awards, which are the two main building blocks of the New York Convention. So when it comes to enforcement of arbitral agreements, again, I think like in the past 2 decades, Russia as a jurisdiction has made tremendous step forward. If we take a look at the practice of 1990s and 2000s, the first decade of the 21st century, there were a lot of divergent practices in the Russian courts about enforcement of arbitral agreements. I recall one colleague saying that the court would use every hook to make sure that it would not enforce the arbitral agreement, and to make sure that it would assume jurisdiction to rule on the merits of the case itself. That was, say, 10 years ago. Now I think the situation has improved. That was done both through case law and through the regulations adopted in the course of the arbitration reform of 2016. I've listed there some of the achievements, some of the principles which have been developed through case law and through these regulations. I will not go through all of them, but like the main idea is that there are less and less opportunities. The window is becoming more and more narrow for the courts to actually reject or apply some creativity with respect to the arbitral agreements. So the actual trend of enforcement of arbitral agreements is positive. I thought of some of the like perennial topics related to enforcement of arbitral agreements. In the interest of time, I would probably say that one of the most challenging ones is the one which is presented in the second bullet of the slide, which we call Russian torpedoes. The situations where Russian parties are torpedoing or truncating the arbitral process by bringing claims in Russian courts and challenging either arbitral agreements themselves or the actual contracts with respect to which an arbitration is being conducted. And that's the problem which still in need for a comprehensive and solution from various angles, because the practices are different. What is called Russian torpedoes actually combines a number of various guerrilla tactics, abusive tactics, which require response. But it should be a sort of a balanced response, because some of the practices are actually not that abusive. They are good, okay, and legitimate. So we need to strike a balance between good and bad situations, abusive and non-abusive situations, and that's something what still awaits a comprehensive solution. I will now move to enforcement of arbitral awards, and we'll generally consider the two topics which I think are the main ones when it comes to enforcement of arbitral awards. One is public policy, another is arbitrability of disputes. Again, we see certain good trends. We started, same with the arbitral agreements, we started with Russian courts interpreting public policy issues quite broadly. Say, I've listed some of the examples from 1990s. Say there were instances then enforcement was refused just because the merits of the award didn't comply with the Russian law when the foreign law was actually governing the merits of the dispute. There were instances where courts were just applying certain protectionist policies towards Russian businesses and not allowing enforcement against companies which may go bankrupt in Russia because of such enforcement. There was, I think I can call that a campaign. There was a campaign in court practice, generally in the practice of higher courts, in, let's say, in late 2000s, beginning of the second decade of the 21st century, where through a number of decisions by the Supreme Arbitrage Court and finally through the 2013 guidance as to application of the public policy exception, the Supreme Courts have promoted restrictive application of the public policy exception, and I think as a result of that, the terrain actually improved. We now see less odious cases of use of public policy, less broad interpretations. However, one can still find quite questionable cases and examples. Again, I've listed a couple of most recent ones. The one which I like most is the second one. There were a series of court decisions, I think 5 or 6, where Russian courts refused enforcement of awards rendered by a Ukrainian Chamber of Commerce because the shareholders of the Russian debtor company have not approved, rendered corporate approval of the transaction based on which the award was rendered. That's a very interesting style of application of the public policy exception. I think that's something what comes very close to, you know, protectionist ideas. At least what we can read out from the judgment. Maybe there was something behind what was actually written in the judgment. Sometimes that happens, that the court has some other considerations, but it doesn't list those in the judgment. It's easier to refuse based on the public policy, which is under full control, or more or less under full control of the court, rather than try to advance complicated theories, even though the court probably believed in that. And the last one, it's about arbitrability. And again, starting from the positive, I think we have quite positive results of the very recent arbitration reform and the preceding case law, because certain perennial problems with respect to arbitrability of various sorts of disputes have been cleared out. We now have clear understanding about what are the rules with respect to arbitrability of the corporate disputes, even though some rules are quite harsh, but like at least there is clarity. We now know what to do in case of bankruptcy and how this affects the arbitral proceedings and arbitration clauses. We now know that real estate disputes are arbitrable. We know that public procurement disputes are not arbitrable, and that no one shouldn't even go in this direction. There is a very concerning trend which I wish to highlight. Probably all of you know about that. There is a sort of a campaign by the higher courts to find out to what extent certain disputes which have, as they call it, high concentration of publicly relevant elements, to what extent such sorts of disputes are arbitrable. And this mantra, high concentration of publicly relevant elements. It's also something what is subject to interpretation, and the courts are still filling in this basket with various examples. Say, one of the most concerning examples is that we see that there are divergent practices about whether Russian private companies where a state owns a stake can go to arbitration just because there is a state interest in these companies. Like there recently that there was a ruling by the Supreme Court where the Supreme Court seems to have accepted that these disputes per se, nothing in these disputes per se is a challenge to arbitrability, but the ruling is still controversial and opens the room for various sorts of interpretation, so the matter is not closed. If in the end of the day we end up with, say, a state-owned companies not being able to go to arbitration, then probably 50 to 70% of the Russian economy will be ruled out of the arbitration terrain, which is, of course, like not a very good result after all. These are high-level observations. Due to the time constraints, I cannot go into like more detailed comments about these issues, but I'm happy to answer questions. And thank you for your attendance.
Thank you, Egor. Do we have any questions to Egor? Okay, thank you. Then I would briefly comment. I would say that I feel optimistic about the public procurement contracts because the legislation says that they are temporarily not arbitrable. So there is the possibility to adopt some regulation that will help to do it arbitrable. Another issue is that Supreme Court recently has announced that they will be issuing the like kind of guidelines on the arbitration, and so we shall also hope that there will be some guidelines in regard of this public interest situation. So I look at it optimistic, and just summing up this first panel discussion, I would say that this discussion shows that there are some jurisdictions such as Japan that we can just try to be to go to this kind of example that can be the aim for other jurisdictions that we discussed today. But on the other hand, the other jurisdictions also show the progress during different time periods, whether it's 50 years or it's 20 years. And indeed, I look optimistic, and we see that all jurisdictions now trying to be better, try to develop their legislation, try to develop their guidelines for enforcement of their awards. And I think it's really very important because joining the convention is not the formal process. So one state can just join the convention and just not apply pro-arbitration approach and not apply the convention truly in the real cases. So that certainly shouldn't be the case. However, we see that there is some space for improvement, and so the question to our second session today, I think, will be whether there's some improvement needed in the convention itself, or the jurisdictions shall work further in application the convention in pro-arbitration manner. So our next session will start, I suggest, in 15 or 20 minutes. So now we have a short coffee break, and please at 7:05 let's start the second session. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you, Jim. Thank you. It was really exciting. So it's not many enforcement proceedings in Hong Kong. I thought that maybe why it's not so many, because not many assets in Hong Kong. 60, 50, 40. It's not a big amount, I think.
No, every year.
Every year, yeah. But so I think for Russia it's.
Oh yeah.
I think it's more, yeah. So it's not much, yeah.
But there are more. I think as a seat of arbitration, it's a lot. You get about 300 cases.
Yeah.
We all have each other's emails, but just in case I formally think Thank you very much.
So you get like a lot of cases, like enforcement
Well,
cases?
I don't know about the number, but I was surprised. I thought that 450, because actually SIC has about 400 cases a year.
Yes, but the enforcement are elsewhere.
Elsewhere, yes, I
Yes,
understand that.
but as a
But because Hong Kong is not very big and this, so